Shock and disbelief. That's the reaction of lawyers for the pressure group Stranek, which filed a suit in court seeking an injunction against the EC's planned activities towards the creation of the proposed 6 regions. There are 2 separate court actions seeking to stop the process. Pressure group Stranek and 2 other individuals have specifically filed for an interlocutory injunction on the entire process. But the EC at a news conference earlier today said it will go ahead regardless. We have lawyers for Stranek with us in the studio for their reaction to this. But first, listen to the chairperson of the Electoral Commission, Jean Mensah, addressing the media today.
With regards to the suit that the service of the writ of summons on us, it was delivered yesterday, but it was not with an application, and therefore it cannot be held to be binding an effective injunction on the Commission. And that's why we are holding this, press conference today and going ahead with the limited registration exercise as planned. I know that it was a gentleman who spoke on the budget. I think this is something that is very dear to our hearts. Over the last few weeks, we've had, discussions on the cost of elections, and we are very mindful of that, mindful that we are managing, the taxpayers' resources, and we'll ensure that we'll use it in the most prudent of manners, and looking at international best practices and other countries across the country. Unfortunately, we are not able to, give you a cost. We've just come in. We are reworking some of these things. We have received some money for it, and I'd like to assure you that the Commission is not cash-starved, and therefore the processes will go on as planned, but we are unable for now to let you know the actual cost. I'd like to assure you that we will make this available in due course.
That's the chairperson of the Electoral Commission, Jean Mensah, there. She also announced a rollout plan. Listen.
Ladies and gentlemen, pursuant to Article 5 of the 1992 Constitution, the Electoral Commission is mandated to hold a referendum to determine whether the voters in the region to be created support the creation of a new region or not. In the light of the above, the Electoral Commission deems it appropriate to brief the press on preparations being undertaken by the Commission for the conduct of the referenda in the 6 proposed regions. As part of the Commission's preparations, a limited registration exercise will take place throughout the country as required by law. Ahead of the referendum, the country would be zoned into 2 for the purposes of this exercise. Zone 1 will affect areas carved out for the referendum and will be held in 47 districts in the proposed 6 regions. Zone 2 will comprise the non-affected areas. For Zone 1, kindly find below the arrangements that we intend to make. The limited voter registration exercise will be done online through the Commission's Voter Management System, the VMS. The registration will take place in the 47 district offices of the Electoral Commission carved out for the referendum. The registration exercise will take place from Sunday, the 16th of September, 2018, to Tuesday, the 25th of September, 2018, and will be held between the hours of 7 a.m. and 6 p.m. each day, including Saturdays and Sundays.
Jean Mensah there, she's leading the Electoral Commission at the moment. I have in the studio lawyer for some of the plaintiffs here. He does not represent Stranek, as I indicated earlier. He actually represents 3 of them: Mayor Aguleze, Destiny Aulime, and then Jean-Claude Koku Amenyaoglo. His name is Albert Kwashiga. Mr. Kwashiga, you're welcome.
Thank you very much.
So you say you're shocked, and are they announcement of the Electoral Commission that they'll go ahead with the plans?
I am utterly shocked.
Why?
Actually, I was on my way to this place when I learned that the EC had held a press conference to announce that they were going to go ahead with the process as planned, because although they have received a writ, it didn't come with an application for an injunction.
Right.
And well, what I can say at this point is that I'm shocked, but we'll advise ourselves on this matter.
So you know that the process will be that if you want them to stop their plans, if you want to basically put the plans on hold, that you needed to bring an application of injunction. Why didn't you do that?
No, we didn't have to bring an application for injunction.
No.
And let me make this point clear.
Okay.
Now, when a process has been filed out of a competent court, and the process seeks to achieve a certain end, and you take steps that would overreach that process, what you're trying to do is to undermine the course of justice. I mean, it's a basic principle, and although the area is still quite gray, it's a basic principle that when a process has been filed out of a competent court, you don't take steps that will overreach the outcome of the process. I think that's what the EC has said that they are going to do. That in spite of 2 suits that have been brought to achieve a certain end, the EC says it will go ahead.
It will go ahead because it doesn't say anything stopping it from going ahead.
No, but I'm saying that if you look at our writ, if you look at the writ we have issued, and we are about to file our statement of case within 14 days, if you look at the writ, some of the reliefs we are asking for have injunctive effects. Now, for instance, if you take a look at release 5 and 6, it tells you that, for instance, we are, well, especially 6,
so,
right?
Okay, so let me read it out to our viewers, and then you give us the explanation why you think this writ that you filed was enough to put a hold on the Electoral Commission's plans. The relief number 6 that they're seeking is says that they're seeking an order for interlocutory injunction directed at the second defendant to prevent the second defendant, which is the Electoral Commission, from holding or organizing or authorizing the holding of a referendum to create new regions until the final determination of the suit.
And then if you take a look at the relief 7, it has the same effect. In fact, we are actually asking that while our suit is about to determine, the Electoral Commission does not go on with the limited registration exercise. This is clear. This is a process we have filed in the Supreme Court. And the EC admits they were served.
Yes.
And they know about this. So what it means is that the courts don't have powers anymore. When you file a process to achieve a certain end, people can go ahead and do what they want to do.
When you heard the announcement of the Electoral Commission, what was your immediate reaction? And if this is of course, is coming from the Supreme Court, then the Supreme Court should be reacting as well.
Well, the Supreme
Have you
Court
had any reaction?
The Supreme Court doesn't have to react. We have to cause the Supreme Court to react on this matter. And so, I mean, as I said...
But from the explanation you're giving me, it presupposes that the action that the EC, the Electoral Commission is taking is some kind of contempt.
Yeah, the Supreme Court cannot react by itself. It is we, the parties, who must invite the Supreme Court to react to the conduct of the Electoral Commissioner.
Okay.
And nothing more. So basically, we are surprised. And I'm saying that I'm not the party in the matter, I'm the lawyer. And so I'm engaging my clients on this matter. And by Monday, you would hear from as the next step to take. Because the process is going to start from Sunday, that's the 16th of September, and then it would end somewhere 25th of September. I believe there's still some time to take certain actions.
Okay, help me understand this. I'm not a lawyer, and I'm not so well vested in matters of law.
Very well.
But would you say that it is the normal practice? Is it the usual practice that when you send a writ like this to an organization or an institution like the Electoral Commission or any government agency requiring, that they hold on to certain actions, and it includes what you have here in the relief 6 and 7, that you're seeking the relief of an order of interlocutory injunction in 6, in 7, an order of interlocutory injunction against the second defendant. Is it usual practice that will just take this and stop what they have to do?
That's why I'm saying that the conduct of the EC is strange.
Please help me with this answer, because like I'm saying, I'm not well vested in matters of law, and I believe that most of my viewers aren't either. Is this normal practice that when you take such a writ to an organization, when an organization like the EC is served such a writ, that they are necessarily compelled not to take any further action?
It depends on the view they take of the process, but ordinarily, when you receive a process like this and you know the reliefs, I mean, you don't want to take a step that will prejudice the outcome of the entire suit. That's why I'm saying I'm extremely surprised, because I mean, as a lawyer, there have been cases where lawyers have come to court to argue that clients have come to court to argue that they have not there's no substantive application for injunction, but the courts have taken the view sometimes that when the process has been filed and you know the intention of the process, you are not supposed to go ahead to take a step. Otherwise, you are making the courts useless. You are saying that the courts should not be allowed to do their job.
Well, like you said,
it's a duty of the courts to pronounce on such matters.
Right.
It doesn't lie in the mouth of an individual or a commission to say that I think that the process that has been filed is defective and therefore I'll go ahead and do what I have to do. We have to defer to the courts, and the courts.
But then, like you said, the courts cannot act on its own.
Yeah, but that's what I'm saying.
Its action has to be triggered by people like yourself.
That's what I'm saying, that today is Friday, right? They're beginning on Sunday. The courts don't work on Saturday, so they'll start the process on Sunday. But I'm saying that I'll confer with my clients on Sunday. By Monday, you will hear from us. Now, they have about 10 days to do this exercise. And so if the EC is saying that there's no substantive application, and we can argue that, we can take other steps based on what has happened so far. But we'll advise ourselves on the way forward. Okay.
Well, so would you agree that it is actually safe to say that your writ actually, or your application that's seeking to stop the Electoral Commission from going on, was not as watertight?
No, I wouldn't say that. And I'm saying that if you respect the rule of law, and you understand the way things work in a democratic society.
Because like you just explained, and I wanted to understand, because I'm not a lawyer.
Yeah, but that's what
I wanted to understand. So hold on for me. I wanted to understand that if you should carry this document, is it only enough? Then you said it depends on how
the view they take.
It means that it's not watertight, because they can still take the view that like they're taking now.
That's why I'm saying that it's still a gray area. Okay. What I'm saying that some courts will take the view that when the process have been filed, and you know that it's seeking to achieve a certain end, you must stop what you want to do.
But it still has to go back to the court for some sort of interpretation.
So we have to go back to the court and ask the court that we filed the process. The EC admits it was served with the process, but the EC said that there was no application for substantive justice, so it disregarded our process and went ahead.
Which means then that your case was not as watertight, so they could get around.
It's not about. It's not about being watertight. Look, at this stage, okay, we are not into the merits of the matter. If you look at what we are asking for, we are just asking for a temporary halt to the process so that we can go through the hearing of the interpretative issues from the Supreme Court. Is that not it? So this is not. So it's not about the content or the watertightness of our suit at this stage. We haven't even gotten there yet.
Okay.
And I know that the Electoral Commission is just trying to be smart about this, but I'm saying that I'll confer with my clients and we'll advise ourselves.
Okay. Yeah. Advise yourself, and let's see what you decide on Monday. We'll be here to cover it and let our viewers know as well.
Very well.
Mr. Kwashiga, thank you so much for coming. Unless you have any final words to say, a very big thanks to you.
Maybe before I leave, I just want to say that, I mean, the impression should not be created that anybody is out to stop a process. If you look at our rates, what we are asking for is that if there must be a referendum on an issue like this, you want to create regions out of existing regions, I think that it's a referendum for which all persons in all those regions must participate in, and not only those people in the areas who actually who want,
because it does make a lot of sense. It does make a lot of sense, because then if you decide that you want you want out, you're not the only one who decides that you want out. That's your position, right?
Just like an analogy. This, I mean, Joy Prime, right? I mean, you have various departments. JoyNews, you have various departments. You have program, you have technical, you have everything. Can technical say that we want to do things a certain way and we don't care about what the other departments say? It is impossible. Okay. And that's a simple analogy you want to put across.
Albert Kwashiga there, his position basically, and for the people that he's representing, Mayor Agbleze, Destiny Aulime, and Jean-Claude Koku Amenyaoglo, they're in court. They're saying that if you want to create 6 regions out of the 10 that we already have, then it should not only take those who want the regions created to vote. Everybody else must take that decision. It should not just be you. But the EC says they're disregarding their writ because it doesn't come along with an application for injunction. They're going ahead with the processes. He says they're going to think of what to do. We'll hear from them on Monday. Mr. Kwashiga, thank you very much for coming.
Thank you very much.
Now, the EC chairperson has also been given updates on how the commission is handling the grievances raised by the main opposition party, the NDC, after they boycotted the last IPAC meeting. Listen.
I think they are friends of the commission, and they are friends and stakeholders in this process. And we've written to them explaining, because they wanted an explanation. And we've explained to them that there were some hitches, and that's why the letter was not delivered to them on time. And we believe that because they are friends of the commission and friends of this process, I don't believe that this should be taken beyond that. I think that they wrote to us, they expressed, their unhappiness because they were invited late, and we have responded in a cordial fashion, and we believe that we will be able to move on with this.
So when are you meeting now?
Next week.
Next week?
Yes.
But the limited registration exercise is on Sunday, right?
Yes.
Yeah, but they are saying that they want to meet the EC before you go ahead with the limited registration exercise.
We've been in talks with them. Don't worry about that. There have been discussions about it.
And has